Asian. Thank you. We also have a dedicated website. So please visit the website when you're able. It's still being uploaded. We haven't fully, it's live and running, but it's still under construction as we continue to improve the information on the website. So it is Liverpool Advocates for Windrush.org. I repeat, Liverpool Advocates for Windrush.org. So have a search in your own time and you will see lots of information as to who we are, what our purpose is, and also information on the Windrush scheme, both status and compensation. Check out the eligibility criteria. Have a read of that because that's important to make sure that the information is applicable to yourself. And also some other information. One of the narrative that we're seeking to change is the narrative of Windrush being a Caribbean issue. We're addressing that issue in two ways. We will continue to promote Windrush as a global issue affecting people from across the Commonwealth nation. And there are 65 Commonwealth nations. So that information is also going to be on our site so that people can have a look and see, oh, my country is there. So, you know, I need to understand Windrush. We know it is the case that many people do not understand Windrush. Particular groups of people think they're exempt from Windrush. Many Africans don't understand Windrush. They see it as a Caribbean issue. And many people from Asia don't see it as their own affecting them. So we aim to change that narrative. So when you look at the 65 country, you will then get a sense that Windrush is more than the Caribbean, it's global. The reason why people may think this way, it's because of the narrative out there in the public domain, the narrative that just focus on people from Jamaica, the first generation back in 1948. So you can't blame people for thinking that because that's what they see. They don't see any Africans coming off the ship. They don't see any Asian coming off the ship. But let's make it clear that the Windrush generation and descendants, it's a continuation of people arriving from the Commonwealth countries from 1948 onwards, right through to 1989. So it does make sense then as to why you did not see certain nation on the first generation HMS Windrush. So that's a little bit about what we're seeking to do. We also have said it's very helpful to have questions in advance of our session so that we can prepare for those responses, the answers. In the absence of getting question in advance, we will still raise some questions and we would still want you to raise your own question. The idea of the Q&A is not really for us to say what you may want to know. We have no idea of that, but we want you to tell us what is it that you want to know what question relating to maybe your own situation, or what question relating to understanding the Windrush compensation scheme and status. That's being said, it doesn't stop the conversation or the question in today's session. Tanika and I had a conversation a few days ago. What we've said, if we don't get sufficient question, we may well finish earlier than the allocated 2 hours, 3 till 5. So we'll just see how it go in relation to question. The other thing I need to mention, that we're not operating in isolation. We operate with other colleagues. We have good links with other organizations. We have good links with other partner organizations. And so if we're not able to give you a definitive response or answer to your question, we hope to get the answer and then get back to you accordingly.
Garrick, sorry, there's a question put in the chat by Weegi.
Okay.
Please, if you can have a read of it yourself.
All right. Okay. Let me just, I'll come to that in a moment. Let me just, yes, I can see the question.
Okay.
Let me just continue. As I said, we do have other partners that we are working with, and we don't have all the answers ourselves, but between ourselves and our partners and network, we hope to be able to provide you with any question that you may raise. And if we're not able to give you the full answer in our session this afternoon, then we will certainly be able to find the answer and get back to you. It's also good to know where you're calling in from. If you can put that in the chat, that's helpful. And also, if you need to contact us, we would need an email address and then telephone contact. On our website, we have a contact page. So you can visit the website and you can put your inquiry into the contact page. Let me repeat this site: Liverpool Advocates for Windrush.org. Liverpool Advocates for Windrush.org. So the contact page is there for any inquiry. Thank you very much. So let me just set the scene before I take the first question. On this platform, we're going to be focusing on a couple of things, but in particular, we want to reach out to people outside the UK, because not many people outside the UK have access to the information and the understanding of Windrush. So in particular, we're concerned about those overseas and how we can connect with those overseas and get information to them. It's also important that you share information so that you can pass information on to those people outside the UK, as well as those in the UK. But we're making a special effort to try and reach people outside the UK because we know the particular issue that they are facing. And we're very interested in returning residents. That is going to be one of our focus. Returning resident. How do they get back to the UK after being out of the UK for a period of time? We're going to be talking about that, and also giving you direction as how you can share that information. And if you have members of your family or friends overseas that will be useful for them to know about returning residents. Okay, so that's the introduction. I'm just going to sort of pause for a moment because I want to give you something else. On this platform, you get more than the Q&A. So, you know, we like to give you a bit more information. And all the information that we give, it comes from the Home Office. So the Home Office provide guidance, both for individual cases and guidance that the caseworker themselves in the Home Office would be using to actually assess your claim. So we will give you reference to where you can find the information, but don't think we've got any special information that is not out in the public domain. It is the Home Office information that we have access to. Some of us have read it several times and we think we know pretty well. Doesn't mean we know everything that the guidance actually says. So we can reference that together. Okay, so Ouija, question one, looking at the website, it does not look as if it's representative of each supposed nation affected. It looks as still as a Caribbean feel, while there is a change. Yes, there will be a change, and it is the depiction and the photographs there does you know, reflect Caribbean people, but we're also going to update with a strap line on the website. On the landing page, when you arrive at the website, it will tell you that Windrush is not a Caribbean issue. And we will have the reference I mentioned, 65 countries, that is Commonwealth. So as I said, it's a work in progress. It's a brand new website. It's only been up for days. And the Q&A, we've only been running these sessions only a few weeks ago. So this is the second month. So we started in October. This is the second month. So again, relatively new. Okay, so that's a means of introduction in the subject matter.
Garrick, before you continue, can you please also remind people to submit questions in advance?
Yes, absolutely. I will repeat that. I've said it and I will keep repeating it. And the reason why we ask for questions to be submitted in advance, 3 to 4 days, so that we can research the question and give you the best response to the question. So make sure we find the answers. It doesn't mean because we, you know, are Windrush advocates, we know everything. So we do need to research and find the answers. If you're not able to do that, giving us the question in advance of 3 to 4 days, even 2 days, we still accept that, but it's better if we have 48 hours time. It doesn't stop you from raising a question here on the day, so that's not an issue. We just want you to sort of prepare because question may be pertaining to your own individual situation, yourself and your family. So that's why it may well be more appropriate to give us good advance notice so that we can research it and bring the answers directly to yourself.
So G put a second question, Garrick, that I'll answer. And the question reads, will you be looking at historic international laws? and treaties regarding the protection of peoples and the freedoms. Example, United Nations human rights, rights of indigenous people, etc. As Garrick has said earlier, but I'll also repeat, we're prepared to look at anything Windrush related. I appreciate that there are international laws and treaties that are applicable, at least in my opinion, from the limited research that I have done so far. And there are a lot of human rights issues. I'm not sure how rights of indigenous people may come into it because we're looking at Windrush. We're not looking at general immigration issues. I do appreciate that a lot of the issues under the Windrush policies are immigration related and therefore lends themselves to immigration law. We're not immigration advisors. We are here to interpret the policies and give you advice to the best of our abilities in keeping with the the um, the intent of the policies that the Home Office has put out in conjunction, reading it in conjunction with immigration laws. Yes, so to answer your question more specifically, yes, if it's applicable, the international laws that you're referencing or mentioning, which you may have in mind, treaties, yes. One person in the call can attest that we've already looked at that. One person sent me a document which have several legislations, UK legislations, that affects Windrush generations and how the scandal was born in itself. So we're prepared to consider any question, including this one which I'm answering now, but if it's not relevant, for example, it's submitted 48 hours in advance and it's not relevant to Windrush, then we will politely say that to whomever on the platform if they can look at the video, the recording after, if that's the case. But if it is applicable, then we will endeavor to get an answer, provided an answer is needed.
It's a good
Well,
question.
G, you said 1 second, Gary. G said it's 400% relevant. Well, please do explain to us because we do not know everything. So, if you've done some reading, G, and you found in the international conventions on the elimination of all forms of racial discrimination, a specific section or paragraph or something that's applicable to the way that, for example, the UK government has treated a certain cohort of people, in this case, the Windrush generation and their descendants, then please bring it to our attention and be more specific. But just to mention um, general legislations, treaties, or whatsoever, we wouldn't exactly know what you're referring to, where your mind is at. Adoption and open for signature and ratification by general. That's great, but what exactly are you speaking about? I do not know what you're speaking about specifically, and maybe the other audience who are watching and Garrick may not even know either. So please do either come on mic and share more with us or put more in the chat here and educate us. Thank you.
Yeah,
Garrick?
it's yeah. Thanks for that, Tanika. And let me just re-emphasize uh, what Tanika just said. So our focus is on the Windrush compensation scheme and status. So question relating to that. However, we do realize that there are cases where there is a borderline between Windrush and immigration. And we are not specialists in immigration law, although we have links and contacts with immigration practitioners. If we're not able to help you with your general question and it's very specific around an immigration matter, then that's the reason why we would need to have that information either in advance, 48 hours prior, so that we can consult with other colleagues to get the answer back to you. And if you also have got information that you think we would benefit not just ourselves but the audience, then again it's important to share that because we don't know the background of people coming on the Q&A in terms of their own live experience and in terms of their professional experience. So again, if somebody has something from either of those, then it's good to share, help each other. But yes, we will try our best to answer your own question. And as I said, the reason why we started the Q&A, because we wanted to know or to assist individual specifically, rather more than general, individual that have a question relating their case, their family, etc. Whereas on the other platform, they may not have that opportunity to actually ask a question relating to their personal situation. The other caution I should mention right at the outset, that in these conversations, we know some family and individual have been impacted so much that the entire family has suffered trauma. And we certainly don't want to re-traumatize any individual. So if you'd like to share something and you think, oh, I cannot really talk about this, then please do not share it in the public arena here. That's more for a one-to-one with one of our advocates. And let me just repeat, these sessions are organized specifically around advocacy to help individual with their claim, whether that would be a compensation claim or a status claim. And so that's why it's more personal, sort of one-to-one. We can assist with your claim, understanding the process and assisting you to get the best result from your claim. It is the case, and we know this, and Tanika will bear this out, that where people have, submit their claim without consulting any individual, often it is the case that that claim, if it is approved, the outcome is less than if it was done with the experience with an advocate. Can you just comment on that for me, Tanika, please?
Unfortunately, that is accurate, Garrick. And it's my personal experience when people come to us after they've made an application on their own, based on their interpretation of the guidance and the application form, they have been rejected or they have been offered the minimum amount for whichever subcategory of the compensation heads of claims that they made a claim under. And unfortunate for us, and I say unfortunate for us as advocates, is that when we see the claims, we're like, why did you, or how, correction, let me retract that. I understand why people may have done what they did. However, had they spoken to someone like myself as an advocate, we could have helped them develop and tell their stories better. So it will be more impactful to the caseworkers that will be reading it. Unfortunately, you have to present a story, and not just a story in the sense of, well, I woke up one day and I went here, or whatever the case may be. You actually have to go into detail, unfortunately, which may end up re traumatizing you, having to put what you've experienced on paper. But unfortunately, that is what is needed. Because if you don't do that, they would not know exactly what you've went through, what harm or hurt you've suffered, what degree you've suffered that harm to, and just the result of it today, many years later. That's what they're looking for before they can say, well, okay, yeah, on the balance of probabilities, this person suffered because they could not prove their legal status or their legal right to be in the UK. They did not have a valid document showing that. So they lost their jobs. They could not claim benefits. They could not get medical treatment. They could not go to college, university. They were homeless. They were held in detention, had to report to detention centers. The list goes on and on and on. So You may not have captured all of that on the paper when you do it yourself, but having spoken to an advocate, the advocate will say, did you go through these things? You can put that then on there. And then I would ask as an advocate, for example, how did it make you feel? What did you do after that? How are you feeling today? Did it cause you to break your relationship to break down, your marriage to break down? Did your children see you in a state of distress, in fear, anxious? Did you lose focus on simple things? For example, not being able to take care of yourself, such as bathing or washing or showering, or being able to feed your children or have a normal relationship that you would have had this not happened to you. So these are the things we as advocates will try to extract from you. It will unfortunately cause you to have to relive painful memories, but it's part of the process. But we are here also at Law to help you after that. So we will be offering you free traumatic counseling. Free. On the NHS, Garrick, what's the waiting time now? Year, 2 years?
Oh, yeah. If you can, if you even can survive for 2 years, it's a long
Exactly.
waiting list. Yeah.
Exactly. And we offer you 3 free sessions. If we determine that you need more, if the counselor who's qualified and a retired nurse tells us that you need more, then we will try to give you more for free. Our services are for free. Garrick, I hand back to you.
Thank you. Let me repeat this because I think this is really so important, and this is really what we're about. The Q&A session and the advocacy, as Tanika has mentioned, is a free service. It's a free service to those living in the UK. It is also a free service for those outside the UK if they access the service. So there is no cost. And Tanika has just mentioned the additional trauma support that is so important to each claim. That is also free, available to any claimant, up to 3 sessions. And, you know, that's with every claim that require those sessions. So the important thing here is really to use this service, reach out to the advocacy service. Yes, we're not suggesting that you cannot submit your own claim. You know, many people are capable of doing that. They can fill out the form and submit the form fine. And what Tanika have said, that, you know, what they get may not be what they were expecting. And that's because of what is written on the application as to the impact that the individual had suffered. And if that information wasn't, you know, sufficient to warrant, for example, 50,000 or 100,000, they will offer you 10,000, if that, and then you'll be absolutely surprised as to why. Why is that? What, you know, after 30 years or whatever, they offer me 10,000. But that is the quality of the application that you submitted. And that's why it's important that, you know, before you submit an application, just consult, reach out. You know, it can also be a friend, it could be another member of your family. Just reach out and, you know, say to people, can you just have a look at that and check this out for me, you know, and see whether they can give you any pointers. But the
Garrick,
other,
can I add something to that?
yeah, go ahead.
Thank you. In addition to that, whatever offer you get from the Home Office is 100% yours. We at Liverpool Advocates for Windrush, we do not ask for a penny. We do not get a penny. Whatever you get offered financially, it is yours and yours alone. So please make that clear. Even if we support you from the beginning, you call us up and we help you from beginning to end to offer, it is yours. We are doing this for free. You're not expected. We do not want you to pay us a penny. If you wish to donate to what we do to help us help other people, you can do so through our website. We do not ask for any monies. That is yours. Just want to make that very clear.
That's a very good point. And if you do approach solicitors, there will be a fee.
Yes.
You know, they will charge you a percentage of what you get, and that may be anything from 20 to 30%. So if you get 100,000, a third of that would be paid to the solicitors. As we said on this platform, there is no charge for the work we do from start to finish. Let's make that quite clear. No charge at all. The other thing that is important, when we talk about application and advocacy work, I'm going to keep emphasizing this because we're trying to reach out to people outside the UK as well as those in the UK. And again, the service outside and inside, it's the same. It's no charge. It is free. With technology, it is very easy now to connect with people across the world as we're doing now. So, you know, application can be submitted from outside the UK, and the advocates will help you to be able to do that. So you don't have to worry about, you know, the person is not here. So how am I going to? The important thing is getting the person's experience, their live experience, out of their head onto application, onto the paper. Yeah. And that's always the difficulty, right? People have locked things away for 20, 30, 40 years. What has happened to them? And we have to then extract that information out and then have to put it on paper so that it can actually represent what you have experienced. And the word that we use is how you've been impacted or what loss you have suffered. Those are the things that the Home Office would be looking at in order to offer you an award. They want to see evidence that you have suffered. And it's worth saying at this point, not everything that has happened to you will be considered as, you know, your claim, because the Home Office require evidence that you have experienced X, Y, Z. You can say something on paper. When you're asked to produce the evidence to support that, what you've said on paper, and you're not able to do that, then that claim or that part of the claim will not be accepted because you've not been able to substantiate that evidence. Let's just give some example of that because I think this is important. Tanika, this issue about, you know, evidencing your claim, your experience, and how the Home Office what the Home Office would be looking for in the evidence to support what you've actually said on paper. And let's just deal with how the law look at these things and how we can actually, you know, what we can confidently prove and what we cannot prove. Just say something about that, please.
That is very, very good question, Gareth. Before I answer your question, however, I would like to invite people to go to our website, which I've put in the chat, and I can put it again. If you like to and check whether you're eligible or you know somebody needs to check, we have a quick eligibility questionnaire on our website. We also have a separate questionnaire on the landing page. Please take it. If you need to contact us, our contact details are on our website. Going to your question, Garrick, the It's a very good question. In law, you need it. Sometimes it says not what you know is what you can prove. Sometimes what you can prove also is not enough. When you're gonna make an application, especially on your own or fill it out, you say to the home office, well, I've lost my job. My employer fired me. Okay, what evidence do you have that he fired you? Did you get a P45? Did you get a termination letter? Did you get a dismissal letter with that employer's logo and stamp or address signature to prove, to substantiate, as Garrick said, that you have been dismissed, you have been fired? But then the question comes, why have you been fired? Was it because of insubordination? Or was it because on the Windrush scheme, in order to be eligible, you could not prove your right to be in the UK, your legal status? Only and if only that was the reason for you losing your job, and you can prove that was a reason with this letter from your employer dismissing you, do you have a claim? So you have to prove everything you say in your application. You just can't say something and then expect it to be okay because you said it. It does not work like that. So be careful what you put on your application. I say be careful with caution, because if you cannot provide evidence to show or claim or substantiate or prove or back up whatever analogy or term or adjective you want to use, you have to prove what you claim, what you're saying. If somebody hurt you, do you have a doctor's letter to say that you were hurt? Did you report said hurt? Was it a physical hurt or psychological hurt? Do you have medical evidence of somewhere or another? Did you report it to the police? What evidence do you have? And whatever it is that you would have suffered, it would have had to be significant. That's the other key word that the Home Office uses in the policy. Have you been significantly affected? And was it in relation to the key question? Because you could not prove your legal status, legal right to be in the UK. So whatever you claim, whatever you say, please think, well, okay, if I say I've hurt my finger, do I have a medical report to say, well, my finger was hurt and it was because I couldn't prove my immigration status, that I lost concentration for a moment and it caught under the machine I was using because I was so stressed out and worked up and scared that I was going to be deported? How did you link whatever it was to your immigration status? You have to prove that link. And unfortunately, a lot of applications that we've seen, people were not able to provide that link with what they've already said to the Home Office. So by the time it come to us as advocates, we now have to try to develop the answers you would have already given, which makes our life harder because you can't take back what you've already said. You now have to try to explain further what you've put already on your application, what you've already submitted. And if you cannot prove what you've already said, you can't take it back, remember? Now, if you try to say something else, then okay, hold up. You claimed one thing a month ago. Now you're saying something else. Which one is it? Which one is correct? Are you lying? Are you telling the truth? Oh no, you're not lying. You're telling the truth, but this is just addition to the first incident. This is, this also happened. Okay. Me as a caseworker, I'll be thinking, really? Are you just trying to embellish the truth now? Can I really believe you? How probable or how likely did this happen? So, me as a caseworker, that's what I might be thinking. However, me with the advocate's hat on now, who wants to support you, who wants to help you get what you deserve, like, okay, I need to know more. I need to tell you I need you to tell me exactly what happened and how it happened. One of the things that happens constantly with claimants that I find really difficult is that we get piecemeal information. They give us a little here and a little there. That does not help us to help you. We are here. We are bound by confidence. We cannot betray your trust nor your information, nor would we. We want to help you. We're doing this off of our own backs because we appreciate the situation that one you find yourselves in, not because of your own fault, because it could have been us. And had it been us, had it been me, I would have wanted somebody to help me too. That's how I'm looking at it. That's how my colleague Garrick looks at it. So how can we help you? Help us to help you, please. Garrick, I'll leave it there. Also,
Thank
Garrick,
you.
I would like us to go through the fact sheet, the September fact sheet, which was
Yes.
updated
Yeah.
October 26th, just because I think it's some important information on
Yes,
returning
I'll
residents.
bring that on the updates. So
Yeah,
thank
thank
you,
you.
Tanika, for what you've said. So let's just re-emphasize how important it is to be able to find the evidence to support what you've said, what you've stated has happened to you. And Tanika gave an example. So if you lose your job, there will be an audit trail to say you lose your job. So again, often people say, well, that was so many years ago, and the company probably don't exist anymore. That's all fine, but there is ways of getting information relating to employment. Every employer will have to pay income tax to the government and national insurance to the government. So there are records to show, yes, Mr. X worked at this company for 5 years in 1967. Um, and it will have date when the employment would have stopped because there was no tax collecting after this period. Okay? So there are ways of finding information, particularly around employment. We have said this before, that sometimes there's just no way that we can find evidence to certain things. Yeah? And of course, there has to be a judgment call as far as the Home Office assessment is concerned. Yeah. But where there are evidence, if you lost your home, for example, you had a house, you lost your home because you lost your job, so your house was repossessed. That old audit trail. Who was the mortgage with? All that building society or bank, there would be evidence that you have lost your home. You became homeless. You had nowhere to live. You stayed at family and friends. You need to find evidence of that to support that. How long did you spend in that place with friends and family? Can they actually confirm that they supported you for 10 years, etc.? you know all these scenarios will help us to understand how to go about supporting what we have said on the application. See, and do not put things down that is not true, because you're not doing yourself any favors by doing that. Yeah, try to the best of your ability to provide the information, as far as you're concerned, accurate. um, to the best of your knowledge, the information you provide is accurate, because at the end of the claim you have to sign the document and say, yes, what is there is accurate as far as I know. So that's very helpful, just to understand when we talk about supporting evidence to our claim. And Tanika mentioned many claims fail because the lack of information on the claim form, because the person just did not put enough information on the claim form, or may not even covered enough years of their suffering on the claim form. Just one other point before I move on to updates, Tanika. the way the Home Office will assess your claim, it will not be assessed on the basis of 35 years or 40 years of suffering. They will go back to a particular date because it seems to be that the Home Office are not going back indefinitely to a starting point of your suffering. They will go back to a date in the 80s. Is that correct? 1985, Tanika?
No, it's not, Garrett.
Well, correct me.
1985 is only for it where the Home Office records go back to on their systems.
Mm.
However, with regards to your suffering, for example, you've lost your job for 35 years, you couldn't work for 35 years, they're not going to give you 35 years recompense. They're going to give you a proportion of that. But one of the things that now they're asking for, and is becoming more apparent in letters that I've read recently, how did you mitigate that 35 years of unemployment if you were unemployed? What did you do basically to get a job? What did you do to reduce your harm, the harm suffered? So, for example, you lost your job, you then lost your house, you were then made homeless, you then were homeless for X amount of years. What did you do to prevent losing your job? What did you do to prevent becoming homeless? What did you do to reduce your years of homelessness? How did you look for a job? Did you look for a room? Who did you contact? How basically what did you do to help yourself? And if you did nothing, then they will be less inclined to pay you the higher end of an award. If you went above and beyond to try to reduce or mitigate the effects because of your inability to prove your immigration status, and I keep going back to that because that is the main question you have to ask with everything that you do, every statement you make, every claim of hurt or injury that you assert on your application form. How did you mitigate it? That then leads into what the Home Office has said, that the hostile environment started from 2007. And that's important because if you lost your job in 1985 and you were out of employment for 5 years to 1990, you had a right to work and to be here. But because you could not prove your status, that 5 years is prior to 2007. They are going to compensate you for any issues or any injuries suffered prior to 2007, providing you can evidence that. Bearing in mind, a lot of us may have went to the shop last week, did our food shopping. Do you still have your receipt today? I don't. So, how many of you would have evidence from 50 years ago, 75 years ago, 25 years ago? So, again, the evidence issue that we spoke about earlier, see how it comes into play again. From 2007 to 2023, which we're in, it's easier to get documents maybe in the last 7, 10, 15 years, but it subsequently becomes harder. HMRC, NHS, they have documents for a lengthy period of time. Housing councils, maybe 25, 30 years if you're lucky. It all depends. So the point is, I cannot definitively tell you for every head of claim how long or how far back the Home Office is going to compensate you. That is down to their discretion, I believe. I don't believe there's a figure or a time period anywhere. It's a case by case basis from my understanding. And they will have to look at several factors, one of which, the most important in my opinion, and I think theirs, how did you help yourself? How did you mitigate whatever it is that you suffered? Whether you could not get medical help, how did you try to help yourself to reduce the effects of your, for example, depression, your psychological trauma, whatever the case may be? Garrick, I hope that answers your question. We
Yeah,
have a question from Rafa when you're
yeah,
ready.
yeah. Thanks for that, Tanika. And you made a couple of points there that really should stand out because um, this point that you Home Office would want to know what you've been doing in finding work for X amount of time? The best answer would be that every time you apply for jobs, you were asked for documentation that you did not have. Yeah. So you couldn't prove your status, hence you couldn't actually take up any further employment. Okay? And that would be the case. And we know that is the case because many individuals who were employed by NHS, for example, as a large employer, they had worked in the NHS for over 20 years, and suddenly the manager asks the employee to bring in documentation to say you have the right to work in the UK. That's because the UK government introduced changes in the law to say and to actually fine employer who do not enforce this, to say that you must make checks with your employee to make sure that they have the right to work in this country. And the employer would have to, check that out. And if you didn't have the necessary documentation, many would have lost their job as a result. See? And if you tried to get another job after that, you would come against the same situation because you do not have the documentation to support the fact that you can work in the UK. So, that is clear. And we have thousands of people that's been their experience.
Garrick, you made a very important point that Rafa, I see your hand.
Yeah,
We'll
we'll
come to
come
you
to you,
after
Rafa.
this. You made a very important point, which I think people need to know. So you said that the employer was made to check. Now, in the 80s, 90s, early 2000s, the employers were checking from what I understand. However, the Home Office is saying that it was not mandatory. It only became mandatory in 2014.
Yeah.
Therefore, if you lost your job because an employer checked, you're not going to get compensated for the last 35 years, as I was alluding to earlier. You'll get compensated from 2014 to 2023, if is the case that you're making your application in 2023 and you meet the other criteria that is necessary. So that's a perfect example where they're now basing it on legislation of when certain things were made mandatory, quote unquote.
Yeah, and that's important because employers certainly didn't want to have a heavy fine, as a result of breaking the law, employing somebody without documentation. Now we know there were exceptions to the rule. There were some people that was paid cash in hand, and there was no documentation, etc. And that still operates where that is the case with certain industry, certain restaurants and other places. They do that. But we're just giving you the information to assist you to understand how you can actually demonstrate that, yes, you could not find work. You lost your job and you could not find work because every time you try to apply and go, you were asked for documentation that you did not have. You could not prove you had the right to work. Rafa, can I take your question, please?
Yeah, sure. Good morning, everyone. Or good afternoon to you all. So I'm just wondering how when you're filing a claim for compensation, how these things apply to the external applicant, because certain things would not apply to us. It'd be different for us. So there's no 2014 law for us, as an example, where we couldn't prove our right to work in the UK because we're outside the UK.
Mm-hmm.
So, and would we still have to prove things in our home country? If my father lost his job, how would that be approached? Because I would now he's outside of the UK, so he now has to provide proof from employers in his local country. do the same rules apply is what I'm trying to
Yeah,
understand.
that's a very interesting question, Rafa, and it's one worth careful consideration. Let me try and attempt to answer some of that. So what we've been talking about has been focusing on UK laws, UK resident living here. The Home Office use a thing called you need to be settled in the other right of abode, settled in the UK. So you live here, and this is your experience. However, for those people who are outside the UK, and they may well have been in the UK at one point before they're outside the UK. So there's several things that we need to think about. Did they actually were they ever in the UK? Did they leave the UK for a period of time? Did they leave the UK permanently to live in their own country? We have to consider all these different scenarios. So let's take the bases. So Windrush, when we talk about Windrush, it says this. It says you need to be either yourself, your grandparents, or your parent, or yourself need to be in the UK by 1973. So that's about arrival, yeah, 1973, and settle from a Commonwealth country. However, from any other country outside the UK, right, outside of those Commonwealth, you need to be in the country from any other country by the 1st of January 1989. But you also must have settled status. Okay, so here we have two things. Now, we know that there are individuals who were part of that settled in the UK and then later move outside and may well be still living outside the UK at this time. And in order to check who is eligible, right, for the Windrush status and compensation, those relevant dates are important. Yeah, 73 and 89 are important. With regards to an application being made from outside the UK and what evidence is required on the application, I will invite Tanika to say something about that.
So thank you very much, Garrick. You started it off perfectly because there are three categories, i.e., you came to the UK from a Commonwealth country, and there are 65 Commonwealth countries as defined by the Home Office as being eligible before 1973. Your parents or grandparents came to the UK from a Commonwealth country before 1973. You came to the UK from any country before 31st of December 1988, and you're now settled. As Garrick said, 1st of January 1989. Their system says before December 1988. That's neither here nor there, in my opinion. But to go back to Rafa's question, which is what we at law we are trying to focus specifically on, because there's a gap in information to overseas applicants. On the Home Office's website, it states, sorry, the gov.uk website states a Commonwealth citizen who was settled in the UK before 1st of January 1973, whose status lapsed, as Garrick mentioned, because they left the UK for a period of more than 2 years, and who is now lawfully in the UK and who has strong ties to the UK. So I'll explain what that statement means, because this is from the updates that I've gotten from the Home Office website that is important for people overseas. That statement states that one, you, your grandparents, or your parents would have had to be in the UK before 1st of January 1973. They would have had to had settled status, i.e. right of abode. So I'm going to digress a little here. When people came prior to 1973, they would have had citizens of the United Kingdom and colonies passports, or they would have been British territory, or some form of they had some form of right or British status conferred on them. So that you first have to establish what that was. Then they may have lost it through to independence, So therefore, they're no longer dependent on the UK. They're no longer a colony. They're no longer a territory. They're just a republic or basically an independent country. You need to ascertain what status you had prior to 1st of January 1973. And that when you were in the UK, because you would have had to be in the UK at some point, either your parents, your grandparents, or you, in order to be eligible or considered under the Windrush schemes, you would have had to have settled status, meaning indefinite leave to remain. You were not subject to restrictions. You did not come here on a student visa. You did not come here on a visitor's visa. You did not come here on some visa which restricted you from accessing health services, restricted you from working, any restrictions whatsoever. You could not have had restrictions. Moving on. It reads, if the applicant is currently lawfully in the UK, which a lot of people aren't, and are not liable to deportation on grounds of criminality or other non-conducive behavior, so that's not applicable to overseas clients. That's more for in-country. That's if they do come back. The part that I would like to focus on, though, is something that I found a bit controversial when I read it earlier. On the site it says, due to a mistake in previous versions of Home Office guidance, some applicants who lost settled status as a result of an absence of more than 2 years prior to 1st of August 1990 and who returned to the UK on some other form of limited leave by that date. This is it. So that part would have, I'll just stop there before continuing to the second part of that clause or statement. So a lot of people would have left the UK after 1973 or before 73, going back to Rafa's question. And then they came back in, say, for example, 1978 or 1980, and they wanted to come in the UK. But because they left more than 2 years, the immigration officer would have said, no, you can't. Your status lapsed and you can't gain entry. Or they may say that you're no longer a British citizen, you don't have indefinite leave to remain anymore. Here it says that that was incorrectly applied. However, it continues to read that once they return by 1990, they would have had to live in the UK continuously since then. So till 2023, today, for example. And that hasn't happened to a lot of people. So even if you had came back, say, for example, 1918, then you left again for more than 2 years, your status will still lapse again. So the entire sentence will have to be applicable. And I'll read it again. Some applicants who lost settled status as a result of an absence of more than 2 years prior to the 1st of August 1990 and who returned to the UK on some other form of limited leave by that date and have lived in the UK continuously since may previously have been issued a no time limit, a NTL document, despite not actually having indefinite leave to remain in law. Where such cases are identified, they should be treated as falling under this eligibility group of the scheme and will be considered for grant of indefinite leave to remain. This is an update from the Home Office on the Windrush Schemes for eligibility details. It was updated on the 24th of October 2023. There's a section specifically for returning residents, which we at Law, Liverpool Advocates for Windrush, will be focusing on. This version was published, this is version 6, published on the 5th of October 2023. And for returning residents, it says that the guidance on the Home Office, it must be read in conjunction together with the immigration rules appendix for returning residents. This is important. So I did some research this morning and it reads that this route is for a returning resident. So in addition to what the Windrush policies on returning residents states, you need to read it in conjunction with the immigration rules on the immigration rules appendix for returning residents. This route is for returning residents, which means a person who previously had indefinite permission to enter or stay settlement. So that's what settlement means. in the UK, which has now lapsed, and who now wants to return to and settle in the UK. I'll repeat that one more time for emphasis. This route is for returning resident, which means a person who previously had indefinite permission to enter or stay settlement in the UK, which has now lapsed, and who now wants to return to and settle in the UK. A returning resident's previous settlement in the UK must have lapsed by operation of law, by operation of legislation, after they were outside the UK for a continuous period. And they have three subcategories to this statement. The first is of more than 2 years under the Immigration Leave to Enter and Remain Order 2000. So if anyone is interested in looking that up, it is Leave to Enter and Remain Order 2000. That's the piece of legislation. That's the subsection 1. Subsection 2, of more than 5 years if they previously had settlement in the UK under the EU settlement scheme. So for immigration, which Windrush and Commonwealth citizens come under, your leave lapse after 2 years. For EU citizens, EU settlement scheme is 5 years. The third, of more than 4 years if they previously had settlement in the UK under the EUSS as a Swiss national or a family member of a Swiss national. So 4 years for EUSS, Swiss SWISS national, 5 years for EU settlement schemes, or 2 years under the immigration rule, which a lot of Commonwealth citizens fall under. It continues, a returning resident cannot bring, this is very important, which has changed because it wasn't this before. A returning resident cannot bring or be joined by a partner or children on this route. Each person must qualify as a returning resident in their own right. And the validity requirements, there are 6 of them. And you have to, according to this, you have to qualify for each 6. So this is an update to the scheme, people. The validity requirements for an application as a returning resident are that the applicant must apply on the UKA, ROA or RR meaning returning resident route, in this case, under the Windrush scheme. The Windrush scheme application overseas form, which overseas residents will need to apply under the Windrush scheme application overseas form. 2, be outside of the UK. 3, pay any required fee. Under the Windrush schemes, there's no fee to be paid. 4, provide any required biometrics. So after you filled out your application, they will invite you to do your biometrics in whatever country you're in. If your country, for whatever reason, does not have facility to do that, they will tell you the closest country or place that you can go to do that. 5, establish their identity and nationality by providing a passport or other document. And 6, have previously been granted settlement in the UK. So this is where your lapsing coming. You would have been here before, had settled status, is lapsed. And this is part of the criteria to be considered as a returning resident. Have previously been granted settlement in the UK, which has lapsed by operation of law legislation due to their absence from the UK. Where any of these requirements are not met, you heard, where any of these requirements are not met, so you have to meet all of these, the application is invalid and may be rejected without consideration of the application. So you have to meet all of those. are repeating in quick succession a returning resident application under the Windrush scheme. You have to be outside the UK. There's no fee to be paid. If there is a fee, you have to pay that. Provide your biometrics if and when required, which will be required. Establish your identity or nationality through a passport or another legally recognized identifying document. Have previously, this is important, have previously been granted settlement in the UK. So you would have to be in the UK at some point and left to be considered as a returning resident. Garrick, I'll wait for you to invite me to explain what the criteria for returning residents are, like the strong ties and stuff like that.
That's all right. Thanks for that. There's a lot in what Tanika have said. Let's try and sort of break it down into little bite size, because it's a lot of information to consume all at once. What's important, as Tanika mentioned, the individual would have to meet the eligibility criteria set out by the Home Office. And there is relevant dates. We spoke about 1973 and 1989, settled status. Very important, settled status. And if the individual was never in the UK, we don't even have to go any further with that situation. They hadn't had settled status. So it's about relevant dates, and it's also what status the individual would have. Need to be settled status. However, Tanika spoke about individual who has been in the UK, went out of the UK, and as a result of that, 2 years and 1 day, their status lapse. Right? And so those are the individual. Many of those are still locked out of the UK, trying to get back to the UK. We're going to talk about that in a little bit more detail. Okay, but then Tanika mentioned that you had to fit in not just one, all of those mentioned. You had to fit into those. So if you were unable to do the 1 to 6, for example, then your application would not be considered. So all of those would be relevant. And there is something that we're concerned about, because it has come up several times, and Tanika and I, we had this conversation. There is some discrimination in law on this, and we're going to seek some direction and advice on this, because the way that EU people, they can be out of the country for a longer period of time, and whereas the Commonwealth people, the 2 year and 1 day, there's no variation. 2 year and 1 day, you can't return. Okay? So there's some we don't know how to address that at the moment, but it's something that we know in law. There is something wrong with that. Why is it that EU get a longer period and Commonwealth countries, getting a shorter period? We're going to pursue that through our immigration lawyers and see if we can, push that. Now, the other thing that Tanika mentioned, the guidance that Tanika referred to, I have it open in front of me, version 6, and that's the guidance that actually says returning residents. And it says the guidance tell entry clearance officers how to make decision on returning resident application. And there is a content, I'm just quickly showing you, there's a content about the guide, contacts, publication, then application for entry. And there's a section that says lapsing leave. And this is what it says. This page provides decision makers with the information about who is considered a return resident, when a person holds settlement, indefinite leave to remain, or remain, they're only permitted to be outside of the UK for a particular period of time, or under certain circumstances before their settled status lapse through the operation of law. The preamble to Appendix Returning Resident set out these periods which reflect the immigration leave to enter and remain in order 2000 legislation .uk.gov.uk. A person whose settled status has lapsed must apply for entry clearance to return to the UK, which can be as a returning resident, allowing them to return to and settle in the UK. Where the application is not a returning resident, it will be asserted by the entry clearance officer under Appendix Returning Resident of the rules. So that's part of the guidance on version 6 on returning resident. Please consult that, because it's important to read the full document. Please consult that. It is available, and to find that, you go to .gov.uk/returning resident visa, or if you go to Windrush, then / again returning resident, you will find the document version 6.
Garrick Allison has her hand up.
Yes. So, as I said before, whatever information that we give, it's the same information that's out there in the public domain that the Home Office or the government would publish, and it's accessible for people to read themselves directly. Okay?
I've just put 2 links to them in the chat.
Thank you very much for that. Yes.
And denoting both.
Yes. Okay? Yeah. So please, in your own time, do have a look at that document and read that in its entirety. We will be focusing on a lot of this information because we are doing a definite, in this session, we will be focusing on returning residents every time, because that is an area that we know that people outside the UK haven't got access to a lot of information. So in each of our Q&A, returning resident conversation will take place. And if there are questions relating to that, then please let us have those questions in advance, 36 to 48 hours, so that we can check the relevant information. And if necessary, as I said, some of this border immigration, if necessary, we will consult our immigration partners for clarification on any of those matters. So this will not be the first conversation around returning resident. We will continue these conversations in each of our Q&A as we go on each time. Alison, can I take your point, please?
Hi, good evening, everyone.
Good evening.
First heard these, information about this scheme about a year ago and the videos that were circulating. I did speak to Roland about this in May. I was under the impression that anyone that had any issues with employment could apply to the scheme to get some form of compensation. Now I'm listening. I was in the UK. I was born in the UK before 1973. My parents arrived in the UK before 73. And as I was listening to Tamika, and I put something in the chat about employment checks, because I went for an interview at a hospital and I was called from the interview room by a female that doesn't look like us. And she called my name. She looked around the room. And when I stood up, she was incredulous. She was Alison Hewitt. She went into the room. She spoke to the people that were going to interview me, came out and said, Alison Hewitt. And from that point, I knew that I was not going to get the job. So with regards to employment injury, Tamika, does this scheme apply to anyone who has had some form of job refusal, interview difficulty, not because of status, but because you are a child of or a descendant of someone who is since deceased, or a child of someone who came to this country in the 60s? Thank you.
That's a good question. Before I invite Tanika to respond, let me just say a couple of things that will just lead into this conversation. We've always keep referring to this because the Windrush compensation scheme and status deals specifically with individual who has a direct link to the Commonwealth, or even those who are outside the Commonwealth, but they would have to have settled status by 1989 in the UK. However, there's also sometimes there's a misinterpretation of discrimination happened to individual, you know, we always refer to that as a different issue. A lot of us have experienced discrimination in many areas of our life living in the UK, whether that would be, you know, discrimination in employment. You apply for a job and you didn't get it, or you know, you felt that you should have got it, and that sort of thing. However, there are some differences, and we'll mention that in a moment. Tanika, what I'd like you to respond to is this point about specifically the question that Alison has just raised, whether or not discrimination, and it's probably how we define, you know, because discrimination may be defined by the individual in a slightly different way. But our understanding of discrimination in employment, and we know there are employment laws to deal with discrimination in this country. Can we just try to focus on the Windrush side of that, please? Tanika?
Yes, Garrick. Thank you for that. Thank you, Alison, for your question. When you asked Alison, I'm smiling. You can probably hear it in my voice. I'm still smiling because it was a really good question, really interesting. And in my head, I thought at the moment, loaded question, because it lends itself, from what you said, partially to Windrush, i.e., as a descendant of Windrush individuals, i.e., who came here prior to 1973, but also it lends itself to immigration rules under employment, to employment law, but not so much immigration. Sorry, I shouldn't say immigration, employment law. I am a consultant paralegal, so I could give immigration advice in that, right? And in that vein, the employment aspect of your question, Alison, is that is more employment issue or lack thereof, because you weren't employed, you went for an interview. Now, if you felt discriminated against, that comes under the Equality Act law. You should not have been discriminated against if that's what you could prove, not what you think, what you could prove happened because of your ethnicity, or frankly, the color of your skin. Now, if you think because of that, you did not get a job, you could put in a complaint against that organization. But you'll need to consult a solicitor to proceed with that. With regards to your question of being a descendant of Windrush generation or parents, my question to you would be, how did they know that you were a descendant of Windrush generation when you went for that interview? So I would not.
May I answer that one, Danica?
Sure, go ahead.
Because my name is very English sounding. The Asian woman who came out of the interview room was looking around for a white Caucasian Alison Hewitt. So when
Yes.
when I stood up and I said, "Here I am, hello," it's almost like she nearly fell backwards. Alison Hewitt?
Sorry.
I've x-rayed Indian patients with a name like Jacqueline Joseph, and rightly so. I would be shocked, but in a nice sort of, oh, because maybe you went to an English school in India, or your parents just wanted you to have an English sounding name. So if you look for Alison Hewitt, you'll find most of the Alison Hewitts on the internet are white females. Now, this happened in the 90s, so I'm not going to complain against this organization. Turns out I would not have wanted to work for them anyway. But she would have known, because if you just quickly glance at someone, either I'm African or I'm Caribbean. Yes.
Yes.
Individual went back into the interview room, came out and called me again, and her voice, the tone of her voice completely changed. Now, only God knows what she said to the all-white panelists in that room. Yeah?
Yes.
So to me, I could say, well, I perceive that she was being racist against a Black African Caribbean woman, but how do I prove it? But just the tone of her voice, and looking around, she wasn't looking at me. She was looking for one of the other white candidates to stand up and follow her into the room. So all of that, if this was played out slowly in like a Hollywood movie, you'd see all of the facial expressions and the body language. You'd see it and you'd know. Well, maybe I'm only seeing it as me.
No, I completely understand what you mean, Alison, and I sympathize, empathize, and could relate. Now, having said that, it would still be your perception. At the end of the day, like you said, how would you prove it? Only God in heaven knows. Now, at that time, you could have said, well, okay, your tone changed, or this is my perception. Why did this happen? You could have questioned it. Or after your interview and you didn't get it, you could raise the complaint and say, well, this is what I felt, or how I was made to feel by your representative or employee. And you're going to pursue it, because in communication, one of the main rules is not what I say, but how you receive what I've said. And if that has offended you, then that's what gets us in trouble. So it's not what I intended and what I meant. So if you felt that you were discriminated in that instance, that's something I would suggest you take up, not now, retrospectively, but with a solicitor at a time. Say, for example, it happened within the last 2-3 months, because I think there's a statute of limitation. I'm not sure for employment law. I think it's about 3 months. So that may fall under employment law or discrimination rules. I can't be sure. But the point is that because it happened so long ago, but somebody else said, I think was Herman, said he has a similar experience. The thing is for us to talk about it. Unfortunately, this is not the platform to do so. However, thank you for bringing it up. It does not fall under Windrush, but it falls on discrimination. Discrimination and racism do not come under, or they're not considered under the Windrush rules. That is something the Home Office is not looking at. They do not consider that when they're making an offer of an award or consideration in your applications.
I just wanted clarity, because this time last year, all the videos were saying, yes, if you fell down out beside the street and outside a white man's house, you can get, and it was allowing us to think that we could get compensation for anything.
I know that has been the case, Alison. We also have seen some of those videos, and we did distance ourselves from the information. A lot of the information was incorrect, and we have said that publicly. A lot of information was incorrect. People were given false information. They turn up thinking that they could get claim for discrimination things, etc., and that's not the case. But one of the important point that and this is why we try to separate those conversations. Employment comes under a different set of laws, separate from the Windrush, and it is correct, Tanika. If you want to bring a discrimination case, you've got 3 months to do so, and it is heard by independent employment tribunal. If the 3-month lapse, then unless there's a really special circumstance, you cannot bring that case at all. And it is true, because I've worked in this field for many years. It is true that you may believe something has happened and you've been discriminated against, but you cannot prove it. You haven't got the evidence to prove it, and so it's just one of those things. You just gotta let it go, unfortunately. Thank you for that. Tanika, what I'd like to
Yes.
do now, we've got like about half an hour. We already started to give update on any changes in guidance, etc., from the Home Office. Can I just ask you now, just to bring us up to speed with any changes from the Home Office that people need to be aware of?
Yes, I would like to continue what I was speaking about before on returning residents. And one of the criteria that may be a hindrance to a lot of people, or they may not have considered in depth, and this is something, this again, this has been updated by the Home Office, is entry requirement. So if you want to come back to the UK as a returning resident, it says a person seeking to return to the UK as a returning resident must apply for and be granted an entry clearance as a returning resident before they arrive in the UK. To do this, you have to fulfill one of the below: strong ties to the UK requirement for returning resident, strength of the ties to the UK. So you have to show as a person's ties to the UK may be evident in a number of different ways. The nature of those ties and the degree of those ties have been maintained during a person's absence will need to be considered when assessing whether a person should be readmitted as a returning resident. So the two key things there: the nature of your ties and the degree that you've maintained those ties whilst you were outside of the UK. And ties include, but they're not limited to, family ties, property ties, if you own property in the UK, business ties, if you have a business with a business partner collaboration with someone else, and length of original residence. One moment. Length of sorry, I was just trying to mute someone who wasn't speaking at the time. Length of original residence and length of time spent outside the UK. So if you'd been in the UK for 5 years and then you left for 15 years, they will look at the time that you spent here and the time that you've left. Garrick, I'll pause there if you want me to go into more detail on family ties, what they'll be looking at.
No, you can pause there. You can pause there. I mean, I've got the document open, and I just been following through what you've said. And again, as I said before, version 6, everyone has got access to this document to read themselves.
Yes.
It's important that we read the entire document to get the full sense of the document. It also talk about length of the original resident, and it also mentioned a person may leave the UK for a variety of reasons. This include access to health treatment overseas to care for a family, and we know that is the case with many who has left the UK to care for sick family members. And when you have a sick family member, you cannot be looking at your watch to see, oh well, it's one year and coming up to 2 year. I must go. You just focus on the sick parents, and so a lot of people, as a result of that, their 2 year has lapsed. Then it says to retire for employment, self-employment, or to study. So you notice these points: to access health treatment overseas, to care for a family, to retire for employment or self-employment, to study. Okay, and just moving up the guidance, any other circumstance, other more specific circumstances, which include support and application, are travel, and service overseas with a particular employer before returning to the UK with the employer. A prolonged period of study abroad by a person who wishes to rejoin the family in the UK on completion of their study. Prolonged medical treatment abroad of a kind not available in the UK. So again, that could be an issue. If that is available in the UK, they would ask the question, why did you need to leave the UK to go outside when it's here? So again, I would be asking that question if I was, a caseworker looking at an application, etc. And then it also says, unintended absent from the UK. Listen to this one. Due to COVID-19 pandemic. So there were people, and this, I think it's important to just focus our minds. There were people who were trapped outside the UK during pandemic, could not return. I know individuals that were trapped in Ghana for over 3 years. They could not return as a result. So again, it mentioned. Additionally, there may be other compelling, listen to the point, or compassionate circumstances not mentioned above which need to be considered. And here is the final point. Each case must be considered on its individual merit. So please do read, check out version 6 on returning resident. Lots of information that you need to know, and also your family outside the UK need to understand. There's other things about parent consent required for returning resident age under 18. So if the person is still a minor under 18. Now, Tanika,
Gareth, there's something I would like. Yeah, go ahead.
I'm just going to say, because I wanted to come in on this.
Okay.
So, I've left out evidence to support an application may include the following 7 points. Would you like to mention that, please?
Okay, sure. Before I do, I would like to emphasize something. I only picked the keynotes for reference on this call today, but at the very end of the document, which just shows how you have to read it to the end of stuff.
Absolutely.
It says there is no right of appeal against the refusal of a returning resident visa.
Very
The
good point.
applicant will have a right to an administrative review. So if you apply as a returning resident outside of the Windrush scheme, there's no appeal. You can only apply for administrative review. However, if you apply through the Windrush scheme, which is where we will be supporting you, there is a right of appeal, and that appeal comes in the form of tiers. So first, the individuals must accept their offer, for example, in compensation. Individuals must accept their offer of compensation before it can be paid. So if they offer you £1,000 for homelessness, for example, you don't have to accept it if you think, well, that's incorrect and you should have a higher tier if there's one available. So you can reject that. So it reads, if individuals must accept their offer of compensation before it can be paid, or if they are dissatisfied, they can ask for a review. This is where the administrative review comes in. This is first through an independent internal review. It's called Tier 1 review under the Windrush schemes. And if someone remains dissatisfied, through an independent review there's a second option, through an independent review by the independent adjudicator, that's Tier 2. Those are the 2 tiers that you can go through. If you're in the UK, which this is a disadvantage to overseas claimants, after Tier 2, the independent adjudicator, you can then you can go to your member of parliament, your MP for wherever you live, and they can then write a letter on your behalf. Overseas claimants do not have this. They do not have an MP because they're part of no jurisdiction within the UK that they can get somebody to advocate on their behalf. So this is where advocates are essential, in my opinion, to support you as overseas claimants. So even if you're capable and competent, which I know a lot of you are, to put together your application yourselves, please ask somebody who haven't seen your application to have a read of it. See if it makes sense. See if it communicates everything that you've experienced. If you've actually said what is it you wanted to say, you meant to say. And in addition to that, how you can develop what you've already said. How you can make it stronger, more compelling, more believable. But it must be true because you have to sign a declaration at the end, as Garrick said already, to say this information is true to the best of your knowledge. Basically, do not lie. Do not fabricate information. Do not tell untruths. I emphasize that because it's very important. I see your hand up, Rafa. Come back to you. But going back to Garrick's request for me to go through the evidence section.
Please, yeah.
It reads that evidence to support your application. Evidence to support your application may be evidence of settled status. That is, that you were settled before 1st of January 1973. This is before the 1971 Immigration Act came into force. And this could be, the evidence could be the stamping your passport or the paper that you had, which is equivalent to your passport then, the vignette, the biometric residence permit, a doctor's record or your school records, something to show that you were here in the UK, that you had settled status before 1973, 1st of January. Next one, details of any family in the UK and correspondences you had with them, but also still that you have with them to 2023. If you're applying today, like today or in this year, show that you've been communicating with them and you have a close, strong relationship. Letters of enrollment. So if you're coming here to go to school, university, so, or that when you were here in prior to 1971, sorry, I should have said that. Letters that you were enrolled, attendance that you went to this school prior to 1971. You've been studying outside the UK for a long period. If that was the case, so for example, you went back to the Caribbean and you went to UE, or you went back to say for example, Ghana, you went to a university there, or Nigeria or Somalia or wherever, something to show that you studied outside the UK for long periods and you have evidence of that. Letter of employment, a letter from a medical practitioner or a professional. Where there are minor errors or omissions in the application and there is sufficient evidence to suggest that the application would be granted, inquiries, this is what the Home Office caseworkers need to do, inquiries should be made to seek clarification or request missing documentation and information. They don't have to do this. This is what they should do. Whether they will do it or not, I'll leave that point alone. However, where a person's leave has lapsed, it continues, and they're satisfied that the requirements in appendix returning residents of the rules, they must be issued entry clearance with indefinite leave to enter. And this other point is very important. This last one, Rafa, see your hand up. And it says, if you are granted indefinite leave to remain, if you are successful as a returning resident, you will get a visa only for 90 days, valid for only 90 days. Basically, you have to travel to the UK within that 90 days and take this up as your country of residence. When you get here, you'll get your BRP, which is your biometric document, and you have to go collect it from a nominated location, generally a post office. Garrett, I'm back to you. Rafa, and I don't know if Roland wanted to come in. He came on mic a few times.
Thank you for that. I'm going to bring Rafa in a moment in, but there's something that you just missed out, Tanika. Let me just re-emphasize that. it says this list is not exhaustive and other evidence can be taken into account. So Tanika gave us a list of different things, and it's not an exhaustive list. Other evidence can be taken into account. So again, I hope that is helpful. And let's just say that again, you've got access to this information yourself. You can read it in your own time, at your own convenience, and please read the entire document to get the full understanding of the guidance, etc. Read the entire document. Rafa, your question, please.
Yeah, sure. Thanks again. I was just trying to understand. Tanika was saying the tier two appeals are available for the compensation scheme, but is that also true of not the compensation scheme, but the original application for returning residents? Not on the compensation side, just
No.
on the
Yeah.
Yes, Rafa.
Tanika.
Yes, Rafa, it is.
Yeah.
Because I'm just in my own experience, I received a tier one option,
Decision.
but I didn't get but I didn't get any option for a decision other than a tier one.
So at the bottom of your letter, did you not see if you wish to appeal something along the lines? I'm just saying it off head from what I can remember. It says, if you wish to appeal this decision or you're not happy with this decision, then you're entitled to a free reconsideration or tier two level where independent advisor will look at it, something to that effect.
So I got that. So I got that after the first application, and I think that's what. So I only got one consideration after the first application. Is it that there supposed to be two considerations after the first application, or is it just?
So what, Rafa? Basically, just message me or I'll message you.
Right.
And we look into that. But from my knowledge, yes, there is two. But if Roland chooses to come on mic, if he was trying to say something earlier, maybe he can correct me on that. But I will look into that, and I'm sure I want to say yes. There's two.
Yeah,
there are two.
Based on this document I just read here, yes.
Right.
And there for the
I didn't seem to get an option. So I got the first decision, and then I was appealed that, and there seemed to be no option after that.
Let Tanika have a look at that.
We look at that, and
offline.
We are your advocates anyway, so we'll apply it. We'll ask for it on your behalf anyway.
Yeah, sure.
So we'll discuss that offline, Rafa.
Okay, cool.
Thanks for that, Rafa. It's a good point. Yeah. Tanika, just pause for a moment. Roland, would you like to make any comments on what you've just heard? Okay, Tanika, what I'm going to suggest now, you made a point, and I think this is so important. I want everybody to really pay attention to this point. For those people outside the UK making application, and Tanika's mentioned it, but I need to reinforce this. It is very important to use an advocate. And there are many reasons why we are suggesting that. Tanika mentioned the fact that when application may fail, for example, and there is no other resource opportunity, we have MPs in this country that we can approach in our own individual constituency. Outside the UK, which Tanika mentioned, that doesn't exist. But if Tanika is dealing with your application as an advocate in the UK and we have some issue about that old process, then we can use MPs here in the UK to challenge any decision, etc. And so that is why it's important to actually make contact with law, with Liverpool Advocates for Windrush, so that we can assist you in that application for returning resident. because you get that additional support. Whereas outside the UK, if you do it completely independent, your own, then as it's been said, if the decision is no, that's where it stops. That's it. There is no appeal process. Any other comments, Tanika?
Yeah, if the decision is no, I was just looking at a decision letter after Rafa asked a question. You could email them. There is the recourse for overseas claimants. You could contact them and say you do not agree with the decision. These are why. Basically, a review in its own right, but it's not defined as a tier 1, 2, or anything of the sort. So you could come back to them. And if you have an advocate, your advocate could develop your responses and come back. But bear in mind, even at tier 1, after you've done your initial application, people, you cannot go back with the same argument, which has been rejected. You have to give them something new, something different, something they have not already considered or made a determination on. So if they've already said, no, you're not entitled, exactly. If they said, no, you're not entitled under the grounds that you were discriminated against and do not cover discrimination, then you cannot go back and say, well, it was racism and discrimination, because those are still two grounds which they do not consider, or they're not focusing on the Windrush schemes. However, if you said, yes, I was discriminated against, also it was because I could not prove my immigration status, well, that's something new. And that is under the schemes, and they will consider that.
Yeah.
So you have to give them something they have not already looked at or considered. Yeah. Rafa, so you have your hand up again?
Yes, I just wanted to, sorry to monopolize.
Rafa, one second, Rafa, just hold on. I just want to reemphasize what Tanika has just said, because that is why terminology and words is so important. When individuals are doing the application themselves, and just doing it, they may not really consider what they're writing. And it's very important that we're using the right terminology, the right words on our application. And if it is the case that we're providing new information, some additional information, what Tanika just said is so important. It is because we could not prove our status. So that's the additional bit that the Home Office team would be interested in. You could not prove your status, right? You did not have the documentation to prove that. And if you actually mention that in the way that you communicate on paper, then that would be very helpful to decide your claim. Rafa, please.
Yeah. So, just what about in my instance, for example, where they chose not to address evidence
Rafa,
that I
just
provide.
before you continue, please do not give any specific.
Yeah. I think what Tanika is saying.
Is that
Rafa, 1 second.
a valid
Rafa,
reason for?
1 second, please. Garrick?
Yeah. What we suggest, Rafa, is that you and Tanika will have a outside conversation about your own case. We don't really want to share information, personal information on this platform, but that can be done separately outside. Yeah.
Yeah, if it's something specific, general, that could be applied to benefit everyone in the chat, then yeah, please do go ahead, but no specific.
Yeah. So that's why I'm just trying to understand for the benefit. Yeah, I'm not going into details, but I'm just trying to understand for the benefit. And this was directly in response to what you said about if it's something different. But yeah, so the request I am in my tier 2, I get response or them. But
we're losing, I think your internet, we're losing some of the audio, so we can't really hear you properly.
In the interim,
that's what.
In the interim, can Herman come on the chat, please? Sorry, the mic. I don't understand your question at 446. I'm not sure what it is. I did see it, but I didn't know how to answer because I don't know what you're really asking. Gary, can you make out Herman's question? It's the two last messages in the chat.
Can I just
Last
answer? Can I just
question,
ask it quickly? Sorry.
Yes,
Am I-
please.
Yeah, go ahead,
Yeah.
Herman.
Yeah. Hi, Garrick, Roland, and everyone else there. Really enjoying this afternoon. Thank you very much. The only question I know, just information prior to this is the 1st of January 1973. Just in your experience, how well are some of the educational authorities like universities and so forth, yes, especially for those who have been stuck overseas, with regard to forwarding some historical information to help back up people's cases? What have you found in your experience, please?
Okay, so thank you for clarifying that, Herman. My experience is that one client I had, the institution that they studied at was closed, so that it no longer existed. However, they had some paperwork to show that they were there, I believe, but that's one of the problems that you may run into, finding evidence from back then if you have not kept it yourself. The universities, I haven't had to ask them to go into their archive to see if a student was there during a period of time. So I haven't dealt with that specific one, but one that I did deal with, the institution was closed. The person had information like the name and date. So we just got to hope that when you submit that information to the Home Office, they can find it.
Okay, thank you very much. Thank you.
You're most welcome.
Great,
Rafa,
Rafa,
I
yeah.
don't know if your signal is back. Go ahead, Gary.
Yeah, Rafa audio was going in and out. Can we hear you now, Rafa? Is it better, your audio?
I don't know. Are you all hearing me?
Yes, we're hearing you. Yeah.
Yeah. So sorry about that. So no, I was just trying to, on the point of your third request for a review. If it's not the same, if it is the same argument, but they haven't addressed your previous points in their response, because I know just basing it on what you said, it has to be a different position from the original position that you sent. So just trying to understand how that works.
Okay, so if I understand what you're saying, Rafa, correctly, is that basically you made an argument, say, for example, discrimination, and they did not answer with their response on your discrimination point. They do not have to answer if they think, if it doesn't fall within their scheme. Even if it does fall within their scheme, if they omitted to answer, then you can say, well, I would like a response on this specific point, if you think that it's an oversight on their part. However, I'm wary to say that the Home Office has discretion as to what they do and what they don't do. We have no control over that. So my suggestion is, if there's something in it, for example, you wanted clarification on, or you wanted an answer to, two options. You could either email them again, pick up the phone and call them. The most they can say to anyone is, no, I'm sorry, I can't help you. It's only a bit of time you would have wasted, in my opinion. Or you write it and you just wait for somebody to come back to you. If you have advocates, you can let the advocates do that for you, or bring it up with them, and they. But if it's an argument that the Home Office said they're not going to entertain, then that's the end of it, unfortunately.
Right.
Okay.
Yes.
Thanks for that, Rafa.
Okay, I understand.
Yeah. We're coming up to 5 o'clock now, so this is our 2-hour session. Let me just give a quick summary, and then we're going to conclude. So today we've been focusing on a number of things. In the second half of our conversation, we started to look at returning residents and the guidance to follow. And there was a number of points made within the guidance, and we urge you to look at that, which is version 6. Consult that and read the guidance in its entirety to get the sense of it. We also strongly recommend that application for returning residents made through advocate, because it's much better to actually use the system we have internally here using law, and we have access to a number of other additional help and support if the application is made through the advocates. We mentioned the fact that although we're not immigration advisors, we've got access to immigration advice. So it's a good idea to actually use law with your application. We will be focusing on returning resident at every session because we think that's important. It's something that we want to address because we started off by saying Windrush is global. It affects countries, 65 countries. So we need to start ensuring that information is penetrating those countries outside the UK. And if you know of individual outside the UK, please share the information with them that they can access our website and they can use our information on the website. You have inquiry, you fill out the inquiry information and it will come directly to us with your query. Let me just give you that site again. So it's Liverpool Advocates for Windrush.org. Liverpool Advocates for Windrush.org, spell or abbreviate LAW. The website, although it's up, alive and running, we're still adding to it to improve it. On the website, you will find information on eligibility. It will also tell you that, Windrush affects 65 countries. And we want to improve that information to the public to make sure that Windrush is understood as a global issue. So that's our question. We also encourage you and anyone else to submit a question, maybe pertaining to your own individual situation without disclosing too much of your personal details. Submit that question 36 to 48 hours ahead of our session. So our Q&A is the first and third Sunday of each month. So again, go to the website, that information is there. And outside the Q&A, we have the Sunday chat with focus on Windrush compensation scheme and status. So that is the second and last Sunday of each month. So there are two opportunities to engage and to get information about Windrush status and claim. So I hope that's been helpful for today. Some of the questions that we discussed, I think were really good points, and just keep doing that. Tanika, finally, anything else you'd like to say before we conclude?
No, thank you. Well, yes, sorry. Thank you very much for attending today. Thank you for your questions, your interaction, and engagement. Remember, we don't know everything. I don't know everything. And one of the things I have learned is that the policies keep updating ever so often, and there's no way to know when the updates are going to come through unless you check. So one of the things I have noted was that the application forms that was used in 2021 have changed now in 2023. So you may have seen a version before, but now there's a new version. And the Home Office will say that they're trying to update and make this the application process more simpler, easier. So please keep checking that you have current and up-to-date information when you go to make your application. Our next session is the 3rd of December. One of the things Garrick and I will try to do also is give you updates at our sessions, just in case you would have missed something. Again, we do not know everything, so please do share with us. Please do contact us if you just want clarification, a quick someone just to speak to. If you need traumatic support, please contact us. We're offering you everything for free. If you have any suggestions how we can make our services better, anything that you think will benefit you and others like yourselves, please let us know. We will take it under advisement. Thank you very much.
Yeah.
Joy H, I saw you just joined us. Apologies, we're just ending the session, but welcome nonetheless.
Yes, thank you. My apologies.
No,
I had a prior
okay.
engagement, but
That's all right, Joy. We've just been saying that the website, the live website, Liverpool Advocates for Windrush.org, is live. There's quite a bit of information, but it's still being updated. It does have relevant information as it is, but we're trying to improve that and make sure we have sufficient information that's relevant to the Q&A and to issues around Windrush. So please consult that.
Yes,
okay.
Gareth,
Thank you.
just so I can add to that, actually. So on our website, you will find on the landing page, we have a questionnaire. We're trying to get as many people as we can to fill out a questionnaire. That will also help us to better help you and provide better services. In addition
Okay.
to that, if you're not sure if you're eligible to the Windrush schemes, we have a quick eligibility indicator, a test, which basically some questions. And depending on your answers to the questions, you'll know whether you're eligible or not. So if you don't
Okay.
want to speak to someone, you're not sure if you're just go to our website and just do the quick test in maybe a few minutes of your time, and it'll give you the information. Also, our contact details are on the website. If you still would like to speak to someone, please do give us a call. Our numbers are accessible through WhatsApp, so it's free from wherever you are in the world if you have internet, and or send us an email. We will check the email and we'll get back to you at our earliest convenience. We're here to
Thank you so
help
much.
you. You're most welcome. Thank you.
Thank you.
Yeah, and Tanika has mentioned the questionnaire. We really want as many people as possible to complete that, because that's going to help us in terms of how we develop and improve services. We want that questionnaire to show that there are still many issues that people are experiencing, and so that is going to be a key way of actually collecting information to say, well, there is still a need for X, Y, Z, or this particular area has not been covered. So please complete the questionnaire, get other people to do the questionnaire. It's going to help us to develop and improve our services as we go forward. So thank you very much for this afternoon.
Sorry, Garrick, if I could just say one more thing, please. Also, if you know anyone in any of the 65 countries the Home Office has identified as Commonwealth nations, please ask them to get in contact with us or visit our website, see if they're eligible. There's 65 countries. Imagine the rest of that. If one person from each of those 65 countries come forward because they're eligible, then we can help them get their UK citizenship back if that's what they want, or if they choose as returning residents to stay wherever they are but claim compensation, then that is also possible, which is on the UK government website, which we've shared with you today. So please let them get in contact with us. There's 65 countries, people. A lot of people do not know about this. So anywhere in the world, just visit the UK government website, see the 65 countries. If you know someone from there, please share the information. Please tell them about it. This recording is also going to be on our YouTube channel. Please reach out to us. We're on Instagram, or I'm in Instagram, Facebook, YouTube. Please find us somewhere. We're here to help. Because when the scheme gets taken off, even though they said there's no end date, then people would have missed an opportunity to rectify their status for free through the Windrush schemes, because passport naturalization now is nearly £2,000 or something like that in the race every year. So please, and plus you get compensation if you're entitled to compensation. So please take opportunity, please take advantage of the schemes, as we don't know when they're going to take it away. Ronan, you saw you came online earlier. I don't know if you want to have something quickly. It's after 5 o'clock now, 10 minutes after 5. So thank you for staying on longer, everyone.
Appreciate that. Okay, can I just say, have a good afternoon. Enjoy the rest of your day, but also visit our website, and all information is there to be accessed, and share the information, please. Thank you. Have a good afternoon or good evening or good morning. Okay, bye for now.